SJC-07874, Commonwealth versus Celester.
Now, Mr. Wood, before the clock starts, because I don't want this to go against your time, and I know it's not your fault, but how do we get a case that's 20 years old before it reaches this court for the appeal?
I'm glad it's not on my time. I am the at least the fourth post-conviction lawyer, and I believe there were at least two, maybe more, trial lawyers. The shortest answer is that after his conviction, there was a lengthy effort to investigate factual grounds for a new trial. And from my review of the docket, and nothing more, it seems that the court, and this is the 1990s, was resistant to giving funds for investigation. And so there were, I believe he was convicted in about 1995. The first new trial motion was filed not by myself, but by his third post-conviction attorney in about 2005. That ultimately, and then there were, I believe, 4 years of litigation of that motion, roughly.
Is that the one that Judge Rufo wrote the opinion?
Yes, that's right. And then the case was, for reasons that are not clear to me, sent back to the second post-conviction attorney to pursue the direct appeal. She then determined, while preparing that there was a public trial issue, and asked me, because I had become the poster child for post-conviction claims for public trial as a result of the Alabord case, to do her the favor of taking the case over and raising a new trial motion. I agreed to do that, not quite thinking how it would look that I now am the
No, we know
standard
this
bearer
is not
for,
on you. I know that's,
Right,
I know it's not on you.
and
but,
yet I'm here answering the question. But no,
well,
I,
yeah,
right.
because you happen to be here. But I
Right.
mean, but obviously it's troubling for us to get
Right.
a case that's 20 years
Right.
old. And,
Right.
and if we were
Right.
to basically say you're entitled to a new trial, then
Yes, and
obviously the person's already spent 20
Right.
years in jail. So,
Right.
I mean, that's a problem
Right.
for us.
And as my argument will reveal, it's a problem for me as well, actually. But ultimately, I took over the case in roughly 2011, 12. I moved relatively
Right,
quickly.
no, I know. Again, it's not. This
Right.
is not about you.
And so here we are. I hope
Okay,
that-
now the clock can start, and we can focus on the merits of the
Right.
case.
This case is rotten to the core. The Commonwealth's entire case against Jermaine Celester is based on three things: erroneously admitted evidence, ineffective assistance of counsel, and prosecutorial misconduct. You can see this clearly by following the prosecutor's closing argument, in which she relied almost exclusively on three things: the improperly admitted hearsay testimony of Joaquin Woods, the decedent, Celester's own statement to police following ineffective assistance of counsel, and three, the prosecutor's own claims, erroneous claims, that one, the car Corinne DiFrancesco saw fleeing the scene, quote, had nothing to do with this, and that State Trooper Mike Arnold opined that only one gun was used in this case. Because this was otherwise a very weak case, it is at least likely, under General Law, Chapter 278, Section 33E, that these errors together influenced the verdict, requiring a new trial.
Can we start there, that this was a weak case for the Commonwealth? The defendant was identified by the second victim and by the decedent. So that's pretty powerful evidence, isn't it?
I vigorously disagree. First, I agree with you as to the contention that this is what the Commonwealth's case was based on: the statement of Joaquin Woods and the statement of Derek Gibbs. So yes, that is correct. That is what Judge Rufo cited. That is what the Commonwealth cites, characterizes as their case. I disagree with the contention that that is, in fact, a strong case. Derek Gibbs' testimony is the most useful. Recounting is his cross-examination by Attorney Davis at trial, which is recounted in my brief at pages 11 and 12. Essentially, Mr. Gibbs says, Jermaine was on my right, we're walking down the street, suddenly he's no longer in my field of vision. for some reason, Mr. Gibbs believes he stopped short, although he doesn't see him, so I don't know how he infers that he stopped short. But in any event, he's no longer in my field of vision. I'm shot down on the ground. If you look at the testimony, I submit that fairly supports the inference that he did not see who shot him, and he ultimately admits he did not see Jermaine shoot him. More importantly, he was shot in the face, in the jaw trajectory.
He was also shot in the neck, wasn't he?
One shot, one bullet. That one bullet went through That one bullet went through his jaw and came out his neck. Clearly shot in the face, no dispute about that. So of course the immediate question is, aside from the fact that he didn't see who shot him, how does he stop short behind you, and then how does he shoot you in the face? So I submit that Mr. Gibbs' testimony is, in fact, not at all credible and not at all indicative of guilt. Mr. Wood's testimony is, we submit, a different matter, which I'm going to cover. I think that the Crawford establishes that that statement was inadmissible. I also think that it comes from Marlene Scott, and we submit that Ms. Scott's testimony was so unreliable that it shouldn't have even been permitted to come into evidence. But in any event, he says to two different people, Officer LaGrice right at the scene, and then to Dr. Mudd, his treating physician in the ER, I don't know who shot me.
That could be interpreted as, I don't know the person's name, because he did say to the police something that suggested that it was just the name that he was missing, because he didn't know this defendant, right? I go through this in great detail in both my main brief and my reply brief. He had been, and it's actually important, he had just been introduced to the defendant and been given his name, Bear, his nickname, Bear, just moments before. So, first of all, to the extent he's saying I don't know his name, there's testimony that he's saying I don't know his name, there's a question why he didn't say Bear. But in fact...
He's just been shot. I mean, he's dying.
Well, to the point... The testimony is highly unreliable. I submit that, first of all, as I'm trying to get to, he did not say this to Miss Scott at all. But to Officer LaGrice at the scene, the police report, his recounting is, who shot you? I don't know. Not I don't know his name, I don't know. And then only at trial is there a subsequent additional question allegedly asked. And that question is, you don't know him, something to the effect of, you don't know him, I don't know his name. I submit that that is highly doubtful because it was not...
Is that LaGrice talking?
LaGrice, that was not in the police report. In the police report, his recounting of this event, he says, do you know who shot you? No, period. And then that is corroborated by his statement to Dr. Mudd, what happened. And then Dr. Mudd, in recounting this, says, I remember it to the effect of, he didn't know who shot him.
Well, but he also, didn't Dr. Mudd also say I didn't ask him?
He said, that's right, but he said what happened. He said what happened.
Well, what happened is different from who shot, I mean...
Right, but then Dr. Mudd recounts, I remember to the effect that he didn't know who shot him. That Dr. Mudd's testimony, all I can do is relay the testimony, that Dr. Mudd's conveys the recollection that he didn't know who shot him. The point is, to Justice Hines' statement, this was not, in fact, a strong case. At best, even if we argue back and forth, this was a very weak read upon which to build a murder case. It was not a strong case. It was a weak case. Even if you could say that possibly that a jury might be able to convict him of this, I submit that when you consider all of the errors under 33E, it is at least likely that all of the errors affected the verdict and we might have a different verdict. I submit that what we're really talking about here is it strong enough to overcome 33E and essentially establish a harmless error? And I submit absolutely not. That's the point. Now, I'm going to change the order in which I discuss these things, these three pillars. First, prosecutorial misconduct. The prosecutor stated that the car Corinne DeFrancesco identified had, quote, nothing to do with this case. That was gross prosecutorial misconduct of the highest order. Ms. DeFrancesco provided police with dramatic exculpatory evidence. Immediately after the shootings, she saw a car backing away from the scene with its lights off. Police broadcast this information. Officer Reardon, who was about a couple miles away, saw the car driving near the scene. When he followed, the driver made a couple quick turns. Reardon stopped the car. Immediately, the driver, another occupant, fled. He stopped the third occupant and seized him. DeFrancesco was immediately brought to the car and said, that's the car I saw leaving the scene.
Okay, but what did the car have to do with the crime? That's the missing piece.
The car is seen, DeFrancesco says that she sees, there's two things. She sees a car with its headlights off, backing away from the scene. It's nighttime, backing away from the shooting. I submit that that by itself is powerful exculpatory evidence. The people in that car, I submit, it's a reasonable inference that the people in that car have something to do with the shooting. Why would you be backing away from a shooting? Is it possible that it had nothing to do with it? Yes, it is possible. But in a trial, I submit, in a murder trial, I submit that that is very powerful exculpatory evidence. Also, the occupants...
Or when they find the car and check out the people and they have nothing to do with it.
No. I vigorously disagree. What they know is that when they stop the car, first of all, the officer starts chasing the car, it makes evasive maneuvers. Second of all, the officer stops the car, two of the occupants flee. So I submit that, in fact, that's also indication that they did have something to do. What I think Your Honor is referring to is they don't find any evidence in the car. They don't find a gun, but two of the occupants fled, and they don't have, none of the three people admit to doing the shooting. That's not proof that they had nothing to do with this. That's merely proof that they didn't say they had anything to do with this. The fact that they're pulling away is, in fact, and the fact that they are evasive when the police chase them, I think, is, in fact, very inculpatory of them and exculpatory of Mr. Celester. But also, there's another important point. Mr. Gibbs testified that there were no cars at the scene, and the prosecutor emphasizes this in her closing argument because she wants him to be reliable.
Ms. DeFrancesco, who didn't testify, correct?
Right.
But when you said she identified the car,
Yes.
Is that in a police report or?
Yes.
Did somebody testify? Did the police testify to that?
No, this is a crucial part of the prosecutorial misconduct. Of course, she couldn't testify. Well, no one else could testify.
I know about, and you don't think that the prosecution looked for well enough, and that they're okay.
Well,
but
it's worse than that. But I'll recount. I'll answer. I'm sorry. Go ahead and ask your question.
Well, I guess my question is, if it was in the police report that she, Ms. DeFrancesco, identified the car as the one she had seen backing up and going,
Yes.
did the defense counsel didn't ask the police officer that or anything about what she said?
He was not. He was not permitted to recount. They recounted. This is what the jury learned. The jury learned that she had seen a car fleeing the scene. An officer I'm sorry. The jury learned that a civilian, reported a car fleeing the scene, or with its backing up with its lights off. That a car was stopped, and this witness was brought to the scene to look at the car, and then taken to a police station to write a report. That's what the jury learned. The jury did not learn the crucial point that she identified this car as the car she had
And
seen.
Mr. Davis wasn't permitted to ask that?
No, because it was, well, I can't remember, I don't want to misstate the record. I cannot remember to what extent he tried, but it was clear to everyone, I believe, is a fair statement, that would have been hearsay. And the judge may have ruled explicitly on that. But what he did do, it was very clear to Mr. Davis that he wanted to introduce that, and he believed at least that he couldn't, and I believe the judge ruled that he couldn't, although I can't cite the page. What he did was read her statement into the record so that it's clear in the record, not in front of the jury, that she had identified this car as the car she had seen fleeing the scene. Now, the second part of this, which I was trying to get to, is it's not merely that the prosecutor didn't look hard enough. That's not it. What's the really dramatic point here is the prosecutor, in explaining they tried RMV records, they didn't work. She says, the location, the attempt to locate her. She says, I want to get this just right. I don't believe she has a criminal record. Transcript 4:148. What she's saying is, I have looked for her criminal record. She does not have a criminal record for purposes of finding a current address.
Okay. And as I understand from your brief, she had current charges at the time.
3,
Okay.
that's right. 3,
So
in the Brockton District Court.
So if the prosecutor is looking at probation records, is she going to find them?
Docket sheets. It's in my record appendix. The cases were open. If she had looked at the docket sheets, which are in the record appendix,
Are you?
I'm sorry.
I guess I'm just trying to figure out, so you're saying that the prosecutor, in looking for somebody, needs to look at every charge that her office is trying?
No. What I'm saying is she can't misrepresent the facts. I submit that there's very powerful evidence that the prosecutor, was lying, or at the very least, grossly negligent. Let me repeat. She says, in the context of her efforts to find this witness, I don't believe she has a criminal record. The clear implication there is, I have looked for her criminal record. The point is, they're trying to find her. The RMV record address didn't check out. The prosecutor is making the clear inference here, or implication. I looked, in order to try and find another record, I affirmatively looked at her criminal record. I'm not saying she has an obligation to look for her criminal record to find a witness for the defense. I'm not saying that. What I'm saying is, if you can't affirmatively make a representation that is false as an officer of the court, that's basic. And I submit that this statement, I don't believe she has a criminal record, is in fact precisely that. It's an affirmative misrepresentation of the fact. And how could the defense have used that? It's very simple. They could have looked at the docket sheet. The docket sheet had her current address, which was 2 blocks from the courthouse.
Can I ask you, what was she going to add to the case for the defendant?
She was going to, I think it's a fair inference that at that time, at the time of this trial, which was only a short time after the shooting, she would have confirmed that, in fact, the car she had seen the car the police stopped a mile from this incident was the same car she had seen backing away from the scene with its lights off. And how would that be important? The Commonwealth would not have been able, well, that would have been corroboration of Jermaine Celester's statement that cars were seen, that he saw cars at the scene. It would have contradicted Derek Gibbs' statement that he did not see a car at the scene. That would have undermined Derek Gibbs' reliability as a reporter, not surprisingly because he's just been shot in the face, but his credibility is crucial to the Commonwealth's case, as we said at the beginning. So it would have been crucial. The prosecutor, in her closing argument, misrepresents all of this. She says to the jury, don't be confused by that red car. That red car had nothing to do with this. Now, that's shocking, because first of all, she has this statement. Forget about her misrepresentation about the criminal record. She just, based on the statement that everybody knew they had, that Miss DiFrancesco had represented that was the car. She had identified that as the car. That was what the record indicated. Yet, contradicting that known record, the prosecutor represents to the jury, that red car had nothing to do with this. That is by itself a misrepresentation of the record. But it's more than that, because she is taking advantage of her own misrepresentation to defense counsel, which prevented defense counsel from going and finding Corinne DiFrancesco and putting the lie to all of this. So she's taking advantage of her own misrepresentations to the court and defense counsel. That's why this is so profound. The second point upon which this case is built is, and I just also note, she misrepresented the opinion of Trooper Arnold. The court had explicitly said, you cannot be saying that he's giving an opinion on there was only one gun. And she says, okay. And then at trial, and closing argument says explicitly that he has an opinion that only one gun was used. But the second great pillar is this ineffective assistance of counsel. We have a very helpful brief from Ropes and Gray, from Macdell Amicus on this. Mr. Celester told his uncle he was scared to go to the police station. His uncle contacts Attorney James Gilden. Attorney Gilden brings Mr. Celester in. He doesn't explain what Miranda is about. All he says is, if you're going to give a statement, you should tell the truth. Nor did he conduct any investigation. He brings him into the police station. He's immediately placed under arrest for murder. He then is read his Miranda rights. Attorney Gilden sits silently. He then affirmatively instructs Mr. Celester to make an inculpatory statement, placing himself at the scene of the shooting for which he had just been arrested.
Can you point me to that? Because I thought that in the judge's ruling on the motion for new trial, that there was no confirmation that he actually did that. Can you point me to that?
I'm happy to give. I'm sure it's in the record. I can't cite chapter and verse, but these are undisputed facts that he said to. He turns to Mr. I think you mean that where did he actually affirmatively tell him to give a statement?
Right.
Yeah. He turns to him. I'm sure that the record will support, perhaps from his affidavit. That's my best guess. That he says, "Okay, Jermaine, tell them what you just told me."
Okay.
It's something like that. We submit that a defendant charged with a crime, facing custodial interrogation, has a constitutional right under Article 12 to counsel. Alternatively, at the very least, We urge the court to clarify that where a defendant in such circumstances has counsel present, he's entitled to the effective assistance of that counsel. Here, Attorney Gilden provided ineffective assistance because of 5 things. First, he failed to advise Mr. Celester of the consequences of waiving Miranda. Second, he sat silently as Mr. Celester waived Miranda rights after having been arrested for murder. Third, he affirmatively instructed Mr. Celester to make an inculpatory statement to police, placing himself at the scene of a shooting.
Well,
Fourth- Sure.
I'm quibbling probably, but I take it that you can look at this, that this is an inculpatory statement, but it's, at least as it was first delivered, it could be seen as exculpatory, right?
Yes, it's an important point, which I have to be very clear about. I began by saying, trace this through misconduct through the prosecutor's closing argument. That ties together all of my arguments, and I submit that it's crucial for a 33E evaluation. Look at the prosecutor's closing argument, and it will become perfectly clear that she relies heavily on Mr. Celester's statement to the police throughout her closing argument.
But so I guess I would just recharacterize what you're arguing. It's that Mr. Gilden at least should have recognized that it can be on its surface exculpatory, but it's got so many inculpatory pieces to it that it's ridiculous to label it as exculpatory.
That's precisely right. And I want to be clear. His statement is entirely consistent with innocence. His statement, it's my view, does not show or prove that he is guilty. But it's clear also that the prosecutor relied on it to support her argument that he was guilty. And the point that Your Honor just made is repeated over and over again in all of the criminal practice treatises which I cite, all of which are building on Justice Jackson's classic admonition that any lawyer worth his salt will tell his client not to make a statement. But then finally, there's a third pillar. I know my time is almost up. The third pillar here is the statement from Joaquin Woods, the kid I was with. I've argued that this was unreliable. Put that to the side. The fact here is that, I'm not conceding it, but put it to the side. I submit that now this statement, this trial was in the 1990s. Everybody thought that this would be admissible as an excited utterance. We now know that the fact that something's an excited utterance is not enough to answer Confrontation Clause concerns. So the question is this a violation of the Confrontation Clause?
I get that. You're not going to have time, I think, to argue that, but there is two questions that I would like you to answer with regard to the Miranda issue. One is there any affidavit of your client who says that if I had been properly advised, I would not have spoken to the police?
No, well, I say my only hesitation is there was a motion to suppress, and I'm not sure whether or not he submitted an affidavit in support of the motion to suppress. But let me be clear, because I think it's responsive to your question. We are not challenging the admissibility of his statement. The claim here...
No, you're claiming counsel is ineffective,
Right, okay.
but to prevail on that, you'd have to show that if he had been effective, something different would have happened, specifically that he would not have spoken to the police. And what is the basis for us to find that?
I submit that if his counsel had been effective in this context where your client has already been charged with murder, that any reasonable attorney following the practice guides would have told his client in no uncertain terms, do not make a statement. And in this case, it's not simply make a statement if you want to. It is, again, Jermaine, tell this officer what you told me. He affirmatively told his client to make a statement. The client also, it's in the record, said, I'm scared, I don't want to go in by myself. I submit that it is more than a reasonable inference that if counsel had been barely competent, by which I mean, don't talk to the police until I've had a chance to investigate this, don't say anything, you're charged with murder, the defendant would have followed that advice, especially this defendant who indicated he was afraid. So it's more than a fair inference that effective counsel would have prevented him from, or simply said, don't talk, and therefore he would have followed the advice and not talked. I have to try to make one last statement. The Commonwealth ends its appellate brief with a blatant, irrelevant, and inappropriate appeal to the sympathy and emotion of this court, arguing, quote, "This case is about the defendant who threatened to take out the witnesses to his friend's murder and then did so." The Commonwealth claims, quote, "His thirst for revenge left Gibbs a quadriplegic and cut down Wood's life at the age of 18. That's their brief at page 58.
This is their brief?
Yes, page
Yeah, but
58.
You do have a rather sophisticated audience for
I
such
understand,
things, so,
but I remind you, this case is about whether Mr. Celester received a fair trial under General Law, Chapter 278-33E. We submit he did not because the prosecutor lied to the jury. Mr. Celester's first lawyer told him to make an inculpatory statement to police after he'd been arrested without any investigation. And finally, the court erroneously admitted alleged hearsay statements that were not reliable. For those reasons, Mr. Celester is entitled to a new trial. Thank you.
thank you.
Good morning. May it please the court. Mary Lee, Assistant District Attorney from the Plymouth District for the Commonwealth.
Can you, I'm jumping right in. I just want to make sure you are going to address the allegations of rank prosecutorial misconduct. and
Yes, the Commonwealth's
specifically.
position is that the prosecutor's closing argument was completely supported by the record.
And also the point about looking for Miss DeFrancesco.
Yes.
Okay.
Would you like me to begin there? Because I was planning to begin with a couple of corrections from my brother's argument. First of all, the quote from my brief is the section on 33E to describe this case in the Commonwealth's position. As we suggest, you should see the evidence when you view it entirely. Justice Gantz asked a question about where there would be evidence that the defendant wouldn't have made that statement. It's in the defendant's record appendix at page 22. That is his affidavit. And he did, in fact, say, if I had known I was a suspect, I would not have made the statement. And he also talks about what Attorney Gilden had told him to do. His position in the motion to suppress that was prior to trial was that he thought he was just a witness and that Attorney Gilden was telling him just go in and tell them, and then the defendant suggested in his affidavit that he thought he would be released. And so he went in and told him that. So that would be where the defendant was basing his argument. Attorney Gilden's affidavit, pre-trial affidavit, there are two, was admitted at the motion to suppress. Attorney Davis was given the opportunity to decide whether to call Attorney Gilden to testify for the motion to suppress, and apparently declined. He had to inform the clerk whether he wanted to call him, and there was no further hearing. And so that affidavit from Attorney Gilden, which is part of the record, was also considered in the original motion to suppress. Justice Hines had asked a question about where is the evidence of the statement. It's the tell him what you told me, which is in the defendant's affidavit as well. I believe it's his post-conviction affidavit. I may even have that. I believe it's his post-conviction affidavit where he said, oh, I'm sorry, no, it's the pretrial affidavit, DR 22, the defendant's affidavit. He claimed that Attorney Gilden told him to tell them what you told me, and the other reference there is explain what happened. You also see that in the trial transcript, which I know is not relevant on motions to suppress, but in the trial transcript, the police officer suggested, this is at transcript 3150, that the attorney said he'll give a statement, and then the defendant agreed he would give a statement. And so I think that answers the factual questions that were left open. Justice Botsford asked a question about DeFrancesco's Board of Probation record and what would appear in that. You can find the Board of Probation record in the Commonwealth's Appendix 30. That was supplied in the context of the motion for new trial when the DeFrancesco matter was initially raised by the defendant in terms of the claims that are being raised now.
And does it show any of these pending charges?
The pending, yes, and unfortunately, because it came at a time long after the trial, you'll see her entire record, but you will see the charges the defendant is talking about, including the dockets that the defendant has included in
And does
his-
it have the right address on it?
Um,
But it was taken late.
This one's much later. So I think we don't know the answer of what the Board of Probation record would look like at the time of DeFrancesco's,
Well,
I'm sorry, at the time of trial.
We don't know.
So my first you know, I know you wanted me to address DeFrancesco and the prosecutor having made those corrections.
Did
I'm gonna
she,
jump
did
into
Ms.
that.
Wright have an affidavit at the motion for new trial?
The defendant submitted an affidavit of DeFrancesco in the motion for new trial. It is in the Commonwealth's record appendix. The defendant did not provide it to this court. And I suggest that, I quote it in my brief, she would not have given any valuable information to the defense based on that affidavit.
Do we know that, or I mean, this is some time after, right?
Yeah, it's sometime after, I
But I
believe
guess
it's
that goes to
2008.
I guess, sort of different, right? I mean, it's sort of like if she were to testify at a new trial, this is what she would be able to testify to.
That was the whole reason for getting an affidavit from her, and instead they got into all her connections, you know, that she had been a victim at times, and she had been a defendant at other times, and that she had
But it
called the
doesn't
police
speak to
about
what she could have
tapes.
said at the time of trial itself.
She puts her recollection about the,
That's what she now recalls. My point being that, you know, had she been able to testify at the time of trial, she might have remembered more.
I mean, presumably, she would have remembered at the time of trial. I haven't looked at the police report, but if the police report that didn't come into evidence has her saying it was the same car, she would have remembered that.
you can look at all these materials in the Commonwealth's record appendix, pages 11 to 14. So the police report, second page of which is the subject of the Commonwealth's motion to expand the record, and I think my brother has agreed to the expansion of the record, given his references in his reply brief. So that is essentially what Attorney Davis quotes in the transcript when he describes this and then offers it for identification. Attorney Davis never offered and never asked to offer that she made an identification of the car. It's not in the record why he didn't. I don't know why he didn't offer it. All the other hearsay about her description of the car, that it's seen backing away, that she went to the to view the red car and then went back to the police station where they took a report. All of that came in, and he never attempted to offer this hearsay statement of the identification. I don't know why. And so that's not something he was precluded from doing. That's something he did not do.
But given that it does exist, how do you explain the prosecutor's argument that the car had nothing to do with it? I mean, if you've got somebody who would say, actually, I saw that car there.
The prosecutor, first of all, Karina DeFrancesco's statement at the time of the incident in the police report is that after the gunshots, she looked out the window and saw a car backing away from the scene with its lights off. She is not connecting it to the shooting, but potentially reacting to the shooting. So that's the best case scenario for the defendant, is that there is a car backing away from the scene. I would suggest that the prosecutor was not in her closing argument saying there was no identification of this car. What she was saying is the police did an investigation here, and the other evidence showed that the car was not involved. And I would point to the testimony of Derek Gibbs that no cars were around. The defendant's statement that he gave to the police said there was a gray Cougar in front of them and that there was a car on the hill with its lights on. I would suggest there was no gun or ballistics evidence found in the red car. That's at transcript 5, page 158. And the occupants were all identified. That's at transcript 546. So there was evidence for the prosecutor to make this argument. And the statement that the defendant points to in his brief is that the prosecutor said, she was arguing why Officer Reardon stopped the red car. He told you why the car was stopped, because the occupants of the car acted suspicious, so he stopped the car. It didn't match the description that was given at the scene, a dark motor vehicle 4-door. This is a red motor vehicle 2-door, and that's at transcript 686. And I would point to the testimony of Officer Reardon at transcript 5, 44 to 45. He testified he received a description of a dark-colored motor vehicle with tinted windows, possibly a 4-door. The car he stopped was a red Ford Tempo 2-door. And then the prosecutor asked, so it is fair to say, Officer Reardon, that you didn't stop the car because it matched the description you were given, but because of your suspicion regarding the people within the car. Isn't that true? And he answered, that's correct. So it suggests her her closing argument is completely supported by the evidence. I think I have misspoken. I said Attorney Davis didn't ask the question about identification. I believe he did ask the question of Officer Reardon. And Officer Reardon said, I was looking at other cars. I didn't see what the woman said. but he never asked the question of Officer Mather, who was the person who took the statement. So I apologize for my misstatement earlier. I don't know why Attorney Davis, who's very experienced and an excellent defense counsel, I mean, he's a premier criminal defense attorney, I don't know why he didn't ask that question of Officer Mather. But it was asked of Officer Reardon and answered, and Officer Reardon didn't know because Officer Mather was the person handling DeFrancesco at the scene. He had taken her from the scene of the shooting to the car and then back to the station to write the report, and it's actually Officer Mather's report in the Commonwealth Record Appendix. I would suggest in this case the defendant knew that Karina DeFrancesco was not going to be a Commonwealth's witness. He knew that the prosecutor was willing to summons her, but the prosecution noted she did not promise to produce her, just to summons her. The summons was not returned. The prosecutor did not know that she wouldn't show up. But I would further point out that counsel, as early as May 1994, and we know this because his investigator testified on voir dire, as early as May 1994, he knew that address was not a good address. His investigator had gone to look for Karina DeFrancesco and couldn't find her in May 1994. And then they evidently didn't tell the Commonwealth about that. He didn't summons her. He didn't run a board of probation record for her, which he could have because the Commonwealth had put her on the Commonwealth's witness list. So under Rule 14, he could have gotten that board of probation record even though it's a defense witness. And I also apologize, I noted a statute in my brief that permits counsel to get board of probation records. I believe that statute only applies in district court, and I apologize for that. Rule 14 lets them get
I remember
it.
an affidavit, though, by Mr. Davis that basically suggests that the Commonwealth was supposed to produce her, whether or not they were going to call her, and also produce any criminal records about her.
He said,
Do you recall where in the record, could you point me to I seem to have misplaced where the affidavit of what Mr. Davis is. Oh, I think it's at your, no, yeah.
I know what, you're correct. I know that Mr. Davis did file two
Was
affidavits
only
in
after
this
the
case.
trial had started was I ever told that the Commonwealth was not sure that the address it had for DeFrancesco was a good address. I had been led to believe, based on representations made to me by the Commonwealth, that not only was DeFrancesco on their witness list, but that they had a good address and had issued a summons for her appearance. The single reason I didn't ask for a BOP record for DeFrancesco was because the Commonwealth had agreed to provide criminal records of its prospective witnesses to me, and I never received any printout of a record for DeFrancesco. I concluded, based on the representations of the Commonwealth, that DeFrancesco did not have a record.
And that is true. He did put that in his affidavit. The prosecutor did not believe that DeFrancesco had a record, and she was viewing this witness.
Do we have
As-
an affidavit from that
We
prosecutor?
do not. We have the statements of the prosecutor on the record before the trial judge. And further, the defendant's investigator testified on voir dire that they knew that DeFrancesco had breaking and enterings on her record. So they knew that she had a criminal record.
But, you know, he's basically saying that he understands that when the Commonwealth represents and agrees that it will produce a witness, as it did in this case of Karina DeFrancesco, I rely on that representation agreement and did so in this case. I specifically told the prosecutor I'd be calling DeFrancesco as a witness if they did not. So, I mean, we do seem to have a question here as to what it was that the prosecutor had represented she would do.
I suggest that the prosecutor stated on the record at trial that she never agreed to produce the witness. She agreed to summons the witness. And that's why and the judge said, you weren't going to call DeFrancesco? And she said, no. And he said, why is she on your witness list? And she said, because I knew Mr. Davis needed her. And Mr. Davis says, that's how it's been all along, that we're trying to cooperate. But the prosecutor clearly stated on the record she never agreed to produce the witness. And the defendant presented his investigator who said that he knew they couldn't find her, having been given the earlier address, as early as May 1994. The trial is September 1995. And further, he knew that she had B&Es. His investigator said she's got some B&Es, but they never ran the record.
Wouldn't the prosecutor, shouldn't the prosecutor have known as well that she had B&Es?
The prosecutor could have run the record. I don't know why she didn't. If she ran the record, she would have seen a record.
And
I
she
don't
would
know
have
why
had a
she
different
didn't.
address, no?
I'm sorry?
We don't know whether she would have had it, whether,
She said she didn't do nothing. She thought that this witness had no record, so she went through the registry of motor vehicle records. She got a different address in Taunton and sent the summons there.
but what was she basing the thought she didn't have a record on?
I don't know the statement for that, because she said, I don't believe she had a record, so I went through the registry of motor vehicle records.
So the investigator knew more than the prosecutor about her criminal record?
The defense investigator, his
But
testimony.
then the prosecutor about a witness's criminal record, that she knew that, that the defense was going to want to talk to?
I think that's reasonable from the transcript, because in transcript 5, the defendant's investigator testifies on voir dire the efforts he has made to try to find Karina DiFrancesco, and he said she has B&Es. And he had gone to that address and couldn't find her. Well, I'm sorry, he had received the information from the Commonwealth, and in May 1994 couldn't find her based on that information. So the defendant had knowledge that the prosecutor didn't have good information on this, and you add to that that the prosecutor is treating this witness as a defense witness. She's not planning to call this witness.
More reason, though, you'd think that she would have investigated the witness's criminal record to impeach her if she testified.
All I can say is it appeared that the prosecutor did not run the record because she did not believe the person had a criminal record.
Can you help me understand with regard to how it played out at trial? Gibbs seems to say that the defendant laid back while they were walking, but then gets shot in the front of the face. How did that play out at trial?
So Derek Gibbs' injuries are described by the medical examiner at transcript 4, pages 121 to 122. And it shows that, and his medical records were also offered. And so Derek Gibbs' entrance wound is the right side of the jaw. It is an exit wound. I'm sorry, he has an exit wound, the back of the left side of the neck. So it's right to left, front to back is the trajectory of the bullet. So Derek Gibbs testified that the three of them were walking down the street, and that the defendant dropped back, and that he heard the gunshot, and he fell to the ground. The medical examiner was able to testify because of the injury. It's the second and third vertebrae of the neck and severed the spinal cord. He went right down. Then Derek Gibbs was conscious for seconds, probably. He could hear Joaquim screaming as further gunshots rang out. Derek Gibbs had testified that no one else was in the area and there were no other cars in the area, leaving the inference, if you didn't have Joaquim's statement, leaving the inference that it is the defendant. He's the only person in the area.
But how do you get from stopping short or dropping back to shooting into the jaw, and not only shooting into the jaw, but going, the direction is front to back?
It's the entrance wound is the right side of the jaw, traveling right to left, front to back. So I don't know if the person's head was turned. I don't.
But it's not. It's just that if the testimony is that the presumed shooter is behind you, it's just hard to see how you get a shot going backwards.
No, I understand. I'm telling you the testimony, that's what you'll find in Derek Gibbs' testimony and the testimony of the medical examiner, that there's no one else around. And then Marlene Scott she sees a person dressed in black run by. The defendant, states that he was dressed in black. And Derek Gibbs also described his clothing.
Counsel, before your time is up, could you please address the ineffective assistance of counsel issue?
Yes. I would like to start with the end result, that even if this court, despite the Commonwealth's opposition, finds that there was some misgivings about counsel's behavior in this case, I would point out that the statement that was offered was exculpatory, and this statement should not cause reversal in this case.
Well,
this is
it placed him at the scene of the crime, so that's not entirely fair to say it's exculpatory.
Derek Gibbs placed him at the scene of the crime.
I understand that, but the defendant placed himself there with the statement, right?
This statement was the only evidence of a third-party culprit. And you can't give the third-party culprit evidence without saying you saw it. And so I would suggest that this was a denial. It was the only evidence of third-party culprit, and the Commonwealth's case, the Commonwealth versus Mejia and Commonwealth versus Womack from this court notes the great benefit to a defendant to have his self-serving statements offered and without having to testify. This was a case where Derek Gibbs had been threatened with death by the defendant on February 3rd. Derek Gibbs did not hear that threat. That came at Kid's house, and it was Cheryl Scott, who is not Marlene Scott, Cheryl Scott, whose kid's aunt, testified that the defendant angrily said all the witnesses would be taken out,
Well, is
meaning...
it the Commonwealth's position that it's appropriate for an attorney to accompany and a person who is going to be arrested? The attorney knew this and suggest to him that he should tell the police what he knows.
I would suggest that the defendant called, when he got in contact with the attorney, this is at Defendant's Record Appendix 24, Paragraph 2, he wanted to surrender himself to tell the police, to tell them what happened.
I'm talking about the legal principle here.
The legal principle is stated clearly in Beeland that the right to counsel during a pre-arraignment, pre-indictment custodial statement, interrogation, is that they ensure that you are informed of your Miranda rights, which this attorney did. He brought him to the station, the Miranda rights were given, the sheet was handed to counsel, and counsel saw the defendant read it and initial it.
And that's
so,
it? That's the only right you have if you have a lawyer there?
In Beeland, this court rejected that there was an Article 12 right to counsel and custodial interrogation, and that is a case where counsel refused to come in and offer advice. I would suggest it has been actualized in terms of Mavrogatakis. There's a real live attorney sitting there ready to help you,
Well, so
willing to help you.
shouldn't it be an effective attorney?
I would suggest, yes, and I would suggest in this case, there was a manifestly reasonable strategy of getting that third-party culprit statement out there.
He hadn't done an investigation
He didn't
yet.
know
He
anything.
had talked to counsel, he knew that there was a murder warrant for the defendant, he had talked to the defendant, they had gone to the scene together, and he had heard the statement, and the statement...
So you're
that-
saying that there was an investigation done?
It's brief, because he's got to bring the defendant into the police station, but he had talked to the police over the phone. He found out there was a murder warrant. He said he would bring the defendant in. He brought the defendant to the scene. That's in counsel's affidavit. They looked at the scene. They discussed the Miranda rights. He said, Attorney Gilden said, they discussed speaking to the police and giving the same statement to the police. That's at Defendant's Record Appendix 24, Paragraph 4. They saw the warrant first, and defense counsel told the defendant, tell them what you told me. So I would suggest that this was a strategy to get that statement out there, and I would note the next day, defendant asked the police if he could speak to them again.
Could that be a manifestly unreasonable strategy?
I don't think so under Mejia and Womack, and I would suggest that if you look at the defendant's statement, which is at transcript 3 in Detective Hunt's testimony, you'll see that every part of it is cumulative or exculpatory. And I would suggest it cannot have caused a reversal in this case. And I would note in Stirk, this court said, apart from the defendant's right to counsel and the exercise of his Miranda rights, he had no other constitutional right to counsel at the preliminary stage of this proceeding. So it asked this court not to change the law, to find that Attorney Gilden did actualize the defendant's rights. They made up a plan, and the next day, when the defendant wanted to deviate from that plan and talk to the police some more, the police called Attorney Gilden. He came down to the station, talked to the defendant, came out and said he's not going to talk to you anymore. This was a strategy. He did some investigation. It was brief, I understand, but there's...
Probably damage control, wasn't it? I mean, he realized that something really bad had happened with the defendant making these statements to the police.
I would suggest this was not damage control, that this was the plan that the defendant wanted. You'll see that at Defendant's Record Appendix 24. He wanted to surrender himself to the police and tell them what happened. He was afraid to do it without counsel. He went there, told counsel what happened, and the counsel said, tell them what you told me. This is not a tell them everything. This is not explain everything. This is tell them what you told me. And when the defendant wanted to deviate from that, counsel came down and counseled him, and the defendant did not deviate from that plan, and that plan was really the defendant's only chance, given the identification by Joaquin Woods and Derek Gibbs, that the defendant was going to get out of this. In addition to the fact that the defendant had made a threat to kill, he had a gun that could have been used to commit the crime. Derek Gibbs saw that gun in September of 1993 when the defendant's friend Squirrel was murdered. And the defendant's home is just around the corner. The police knew that before the defendant ever got to the station because they'd looked for him there. I realize my time has gone over, but I am,
Got two more, I've got
Yes.
two more questions. One is, assume for the sake of this argument that we say it's manifestly unreasonable for defense counsel to do what he did. What is your argument as to whether or not it meets the second prong?
that he lost no substantial ground of defense because the defendant actually gained a defense here, third-party culprit.
Okay, and then the second question, I'm sorry, that addresses my concern. Okay, I mean that's your argument. Your argument is that there was no, I'm sorry, the second question is there any court anywhere that has granted a new trial because of counsel's conduct with regard to a Miranda statement?
I don't know of one in this state. I don't believe that the amicus brief citations support that claim, but I can't say to the court that I know for a fact that one of those doesn't exist somewhere.
Okay,
I don't.
but you've seen none.
The purpose of the exclusionary rule is to deter police misconduct, not to give the defendant a remedy for something someone on his side has done.
Okay, any further questions? All right, thank you. We'll take our morning break.
Thank you.